Greetings from National Resource Center, Sri Ram College of Commerce, University of Delhi. Today I shall be discussing with you the origin of the Limited Liability Partnership Act 2008 in India, and a brief overview of the main provisions of the Act shall be discussed in today's lecture. In the end, a highlight of recent developments in LLP structure are being discussed. Now let's begin with the historical account and objectives of LLP. Now we all know that partnership constitutes the oldest known legally accepted model of business organization involving more than one person. It reflects any sort of association between persons who pool their resources with a view to carrying on business and to achieve basically the profits and losses, to distribute the profits and losses amongst themselves. Now with the growth in human civilization, business organizations complicated. This in turn required the law to respond, sometimes by mere recognition and sometimes by creation of a newer business forms. The concept of a limited liability partnership surfaced in response to the great real estate and energy prices crumple in 1980s and the consequent impact it had on the banks and other financial institutions. Now since nothing much could be recovered from these failed financial institutions because of the crisis which was there, the attention actually then shifted to whom? To the lawyers and the accountants who had represented these failed financial institutions before their collapse. Now the first law in LLP was enacted by Texas on 26th of August 1991. The other states of the US soon followed. Around the world, unincorporated business associations have evolved to play a significant role in economic life. In the United States, the limited liability corporation form is now preferred by entrepreneurs and established businesses. Countries around Europe have also begun to introduce new forms of business associations to compete with the corporate form so as to better meet the needs of small and medium business and professional associations. In India, in 2008, passed a groundbreaking law to allow for the limited liability partnership. The Indian LLP Act was the first major introduction of a new business form in India in over 50 years. While the partnership and corporate forms have long flourished in India, we all know that very well, but both forms have presented challenges for certain Indian businesses. In 2014, in a report, the government noted that about 95% of firms in India are micro, small and medium enterprises, and only less than 2% of these firms are corporations, given the higher compliance cost associated with the Indian Companies Act. The Indian LLP Act 2008 draws heavily upon the English LLP Act 2000. Now the introduction of the LLP form is tied to India's rapid economic growth in the 1990s. Ministry of Corporate Affairs, that is MCA, has described the impetus for the LLP Act as a desire to develop a business form that could better meet the needs of the entrepreneurs and professionals with respect to liability, exposure, regulatory compliance cost and growth. In India, the Companies Act and securities regulations impose significant mandatory requirements on Indian corporations. So it is not surprising that a freedom of contract was required, and that was the driving force behind the adoption of LLP form in India. The MCA states, with the growth of the Indian economy, the role played by its entrepreneurs as well as its technical and professional manpower has been acknowledged internationally. In this background, a need has been felt for a new corporate form that would provide an alternative to the traditional partnership with unlimited personal liability. We all know that partnership have got unlimited personal liability, and there is a statute-based government structure of the limited liability company on the other hand. So basically it was enacted to enable professionals and entrepreneurs to organize and operate in a flexible, innovative and efficient manner. The first discussion of the LLP law took place in the 1990s. It all started in 1990s. In 1997, an expert committee on development of small sector enterprises headed by Dr. Abid Hussain, a noted Indian civil servant and diplomat, recommended a new legislation to allow for the creation of the LLP. The Abid Hussain committee recommendations lingered without much action until a comprehensive report was issued by Naresh Chandra committee in 2003. Discussion of the LLP form was again raised in 2005 in a report by J.J. Irani committee. Now, similar to Chandra committee, the Irani committee recommendations also provided for the LLP structure as a new form of business association. Naresh Chandra committee noted that in order to encourage the Indian professionals to participate in the international business community without having a fear of being subject to excessive liability or the need of having a legal structure like LLP was required. Chandra committee noted that the Partnership Act 1932 limits the general partnership to 20 persons. Now, this restriction on size would prevent the growth of the professional firms to the large entities operating on international scale. It further stated that since LLPs are now accepted non-corporate entities even in developed countries like the US and UK, it is appropriate to enhance the global competitiveness of our professional firms by ensuring that India's company law is flexible enough to provide mechanisms and instruments which foster growth of the large professional firms. Irani committee recommended LLP form in projects which involved foreign direct investment, that is FDI, which would encourage entrepreneurs to explore business ventures with foreign investment and collaboration. Extending LLP form to small businesses would enable these businesses to enter into joint ventures and agreements that would maximize access to the technology, harness the business synergies, and would better enable the businesses to compete globally. So, to make these organizations global, it was the need of the hour to have a different structure of business as compared to what was there in the present. LLP structure thus would fill a gap between the business forms such as sole proprietorship, partnership and companies. It would foster the growth of the service sector and provide a platform for small and medium enterprises and professional firms to conduct their business or profession in an efficient manner, and it would increase their global competitiveness. Now, all these recommendations were followed by MCA, that is Ministry of Corporate Affairs, which in later 2005 issued a concept paper supporting the adoption of the LLP law in December 2008. So, finally, the LLP law was framed. The cabinet approved the LLP bill. It received the assent of the President on 7th of January 2009, and thereby afterwards it received the legal status as a Limited Liability Partnership Act 2008. Now, many provisions of the Act came into force from 31st of March 2009. It applies to whole of India. But let me tell you, the main lobbyists for the bill have been Confederation of Indian Industry, that is CII, and the Federation of Chambers of Commerce and Industry, popularly known as FICCI. Now, the objective of the LLP law, if we understood according to the background that we have already discussed, it is quite clear. It seeks to achieve the benefits of both the partnership and company as a form of business organization. So, a limited liability partnership is a form of business organization in which the liability of the partners is going to be what? Limited to the extent of their interest in the partnership. And since it has a company type separate legal personality, it will have the organizational suppleness and Since it is going to be in the nature of a partnership firm, the tax treatment of the partnership is going to be applicable to LLP. Even the Insolvency and Bankruptcy Code, which has been recently passed, also recognizes an LLP with the meaning of the corporate debtor, and it seeks to cover resolutions relating to defaulting LLPs. Now let me discuss with you one of the very interesting decided cases. Recently, the National Company Law Tribunal, Chennai bench, in a case of Real Image LLP and Cube Cinema Technologies Private Limited, approved a scheme of amalgamation involving the merger of an LLP into a company. It is quite a landmark judgment, considering that LLPs and companies are governed through separate set of legislations. There are separate laws which are governing both of them. The NCLT judgment signifies a harmonious assimilation of both the laws, wherein LLPs are brought at par with the companies under the Companies Act 2003. A merger of a foreign LLP with an Indian company is specifically permitted, but there is no specific provision for merger of an Indian LLP into an Indian company. Hence, the Chennai bench of the NCLT observed that if we can allow a foreign LLP to be merged into an Indian company, I don't think so the intention of the law would be to prohibit the merger of an Indian LLP into an Indian company. So as a result, this amalgamation was allowed. Now let's begin with the major provisions of the LLP Act. Now let's first of all begin with what is a limited liability partnership. As per the Limited Liability Partnership Act, limited liability partnership means a partnership which is formed and registered under this Act. Since LLP contains elements of, as I told you, both a corporate structure as well as a partnership firm, the LLP is called a hybrid between a company and a partnership. Now I will be first discussing with you the basic features of the LLP in brief, and then one by one slowly some of these features will be taken up. Now as I have already told you, LLP is an organized model of business. It operates on the basis of an agreement like the common partnership without the necessity for complying with detailed legal procedural requirements. Its main features are, the very first one, that it is a body corporate. LLP is a body corporate formed and incorporated under this Act, and it is a legal entity separate from its partners. The LLPs are required to register themselves with the Registrar of Companies, that is ROC. The second point relates to perpetual succession. Perpetual succession means that LLP shall be continuing even if the partners come or go out of the LLP. It shall not affect the existence, rights or liabilities of the limited liability partnership. The third point is related to LLP agreement. Now the mutual rights and duties of the partners of an LLP and those of the LLP inter se shall be governed by an agreement between the partners or between the LLP and its partners. Now what about the liability? As I have been discussing with you, the LLP would be fully liable for its acts because it's a separate legal entity to the extent of its assets. The partners would be liable to the extent of their contribution, but in some cases, we'll be discussing that the liability of partnership can be unlimited. Now regarding the number of partners, fifth point relates to the number of partners. Every LLP shall have at least 2 partners and shall have at least 2 individuals as designated partners. There is no limit on the maximum number of partners. Now the next question comes, sixth point is, who are going to be the partners? Any individual or body corporate may be a partner in a limited liability partnership except a person who is of unsound mind or a person adjudged insolvent or to be adjudged insolvent. Minors cannot be admitted into the limited liability partnership. Seventh point relates to non-applicability of the provisions of the Indian Partnership Act 1932. The provisions of the Indian Partnership Act 1932 shall not apply to LLP unless it is specifically provided by the government or by law. Now, eighth point relates to the power of the central government. Central government shall have the powers to investigate the affairs of the LLP whenever it feels like. Ninth point relates to conversion to LLP. A partnership firm, a private company or an unlisted public company are allowed to convert into LLP. 10th point talks about the winding up. Now LLP may be wound up voluntarily or by the tribunal. 11th point relates to the accounts. Now LLP, just as the other companies, has to prepare an annual account showing the state of affairs, and they have to be filed with the registrar after being audited if it is required to do so. 12th point relates to the financial year. The financial year of an LLP shall be from 1st of April of a year to 31st March of the following year. In case, like for example, let's say if the LLP is incorporated after 30th of September a year, the financial year may end on 31st March of the year next following that year. Example, if LLP is incorporated on 10th of October 2014, let's say, then its financial year should end on 31st of March 2015. But since it is incorporated after 30th of September 2015, its financial year will end on 31st of March 2016. Now, who can be the beneficiaries of LLP? It could be utilized for enterprises such as, number one, persons providing services of any kind. Second, enterprises in new knowledge and technology based fields where the corporate form is not going to be suitable. Third, for professionals such as chartered accountants, cost and works accountants, company secretaries and advocates, etc. Fourth point, venture capital funds where risk capital combines with knowledge and expertise. The fifth point is professionals and enterprises engaged in scientific, technical and artistic discipline for any activity relating to research, production, design and provision of services. Small sector enterprises, and lastly, producer companies in handlooms and handicraft sectors. They all can be the individual, they can formulate the LLPs. Now let's begin as to what is an LLP agreement. Now to provide the organizational flexibility, the LLP Act provides a great deal of autonomy to the LLP and its partners in matter of organization and structuring. The relationship between the partners and the LLP and between partners inter se, including any admission to or withdrawal from the LLP, is primarily governed by the LLP agreement entered into between the partners at the time of entering into the LLP. Thus, as in partnership, LLPs in India can organize their internal structure based on a negotiated contractual agreement. But there is no legal obligation to do so. So, if there is no LLP agreement which has been formulated between the partners, then the mutual rights of the partners and their relationship of the partners and LLP are going to be governed by the rules contained in the first schedule of the Act. Now, in one of the decided cases, that is Hales versus Hood and others, the legislation noted that in an LLP, a member has a share and an interest in the LLP. But there is, however, no definition of a share or interest, nor is there any explicit guidance given as to what a share or interest comprises. Broadly speaking, a member of an LLP will have financial rights and obligations. Now, financial rights and obligations like what? For instance, a right to share in the profits, it becomes a right, and an obligation to contribute capital, it becomes a obligation, and it shall also have governance rights and obligations. For instance, the right to vote on various LLP business and administrative affairs, it's a right, and the obligation to comply with the certain contractual and statutory duties is going to be an obligation. It was noted that a member will have an economic interest and a management interest in the LLP. The nature and extent of these rights and interests for any one member are definitely going to vary depending upon the time and the context in which they are being considered. However, the share of a member is totality of the contractual or statutory rights and obligations of that member which attach to his membership, and an interest of a member is one or more components of his share in the LLP. Now let's begin as to how the LLP is going to be incorporated. How is it brought into the registration? The registration of LLP has been made compulsory under the Act. As I have already told you, it is supposed to register itself with the Registrar of Companies, ROC in short. The new users have to register themselves at llp.gov.in. Basically, it will help them to avail the services which are available on the portal for the LLPs, and also it will help them to file the forms electronically. Now, what is the process of registration of LLP? That I will be discussing the few steps with you one by one. The step 1 is obtaining digital signature certificate. Step 2 is applying for director identification number. Step 3 is approval of name. Step 4 is incorporation of LLP, and step 5 is filing of LLP agreement. Now let's discuss these steps one by one. Step 1, digital signature certificate. We call it DSC. Now before we go for digital signature certificate, the very first task of an LLP is to select the proposed partners and proposed designated partners of LLP. Thereafter, one has to apply for the digital signature of the designated partners of the proposed LLP. This is because all the documents for LLP are filed online. They are required to be digitally signed. So, the designated partner must obtain their digital signature certificates from the government recognized certifying agencies. Step 2 is Director Identification Number. We call it DIN. Now, one has to apply for the DIN of all the designated partners or those who are intending to be designated partners of the proposed LLP. Now, in case there is already a Director Identification Number, it can be used as Designated Partner Identification Number, that is DPIN. Now, the third step is reservation of name. Form LLP Run, that is LLP RUN, we call it Limited Liability Partnership Reserve Unique Name, that is to be filed for the reservation of name of the proposed LLP. The name should not be similar to already existing name. The registrar will approve the name only if the name is not undesirable in the opinion of the central government, does not resemble any existing partnership firm or an LLP or a body corporate or a trademark. The form Run LLP has to be accompanied with fees, but this form may be either approved or rejected by the registrar of the companies. Step 4 is the incorporation of the LLP. Now, after these things are being done, the form used for incorporation of LLP is FILLIP, F-I-L-L-I-P, that is Form for Incorporation of Limited Liability Partnership. It shall be filed with the registrar who has a jurisdiction over the state in which the registered office of the LLP is situated. This form will be an integrated form. It could also be utilized for applying for the DPIN, that is Designated Partner Identification Number. If an individual who is to be appointed as a designated partner does not have a DPIN or DIN, he can use this form to apply for the same. The application for reservation of name can also be made through FILLIP. If the name that is applied for is approved, then this approved and reserved name shall be filed as the proposed name of the LLP. Now let's move on to the filing of Limited Liability Partnership Agreement. LLP agreement governs, as I have already told you, the mutual rights and duties amongst the partners and also between partners and the LLP. LLP agreement must be filed within 30 days of the date of incorporation. If let's suppose it is not filed, then I told you that you can go for the provisions of Schedule 1 of the Act. They are going to be followed. And this entire process of incorporation generally takes 15 days, subject to availability of all the documents. Now let's discuss the issues governing the LLP structure at present, in the present scenario. The very first point is LLP and law firms. Now, years after LLP's Act passed in 2008, law firms are still unsure about whether they may organize LLPs or not. In 2011, Bar Council of Delhi sent warning letters to law firms converting from partnership to LLP, causing at least one firm to shut down its LLP entity. Subsequently, reports indicated that the chairman of the Bar Council sent letters prematurely, but the incident illustrated general confusion created by law. Since then, Bar Council has failed to clarify its stance on whether incorporation as an LLP violates any of the rules under Bar Council of Professional Conduct. The Bar Council of India has not yet taken view whether LLP firms can practice law or not. The second point relates to foreign direct investment, that is FDI in LLPs. To promote foreign holdings in LLPs, the Reserve Bank of India, that is RBI, liberalized its policy for accepting FDI in LLPs in March 2017 by making amendments to the Foreign Exchange Management Regulations 2000. Now, new rules allow LLPs by foreign entities to perform downstream investment in any other company or LLP operating in sectors in which the foreign investment is allowed. RBI also permitted investment under automatic route only in sectors or business activities where 100% FDI was permitted under the automatic route without government approval, and there were no FDI linked performance conditions which were there. In addition to this, the other changes included which were there were that availing borrowing from abroad, external commercial borrowings or ECBs were allowed for the LLPs. But however, RBI rules excluded citizens or entities of Pakistan and Bangladesh to invest in the LLP. In 2017, SEBI, Securities Exchange Board of India, allowed LLP's membership and listing on its stock exchange. Now let's discuss the third point, which is related to amendment in LLP Act to keep a check on the shell companies. The Ministry of Corporate Affairs, MCA, is planning to tighten the norms for companies seeking to convert themselves into limited liability partnerships, as it is very easy to convert. The move is basically aimed to keep a check on the shell companies. The MCA will amend the LLP Act for the purpose. Further, a committee will be set up to recommend changes in the Act. Conversion of companies into LLPs picked up pace in the past 3 years because of easy rules giving rise to an apprehension that these may be shell companies. The number of firms that got converted to LLPs, can you believe, has doubled to 6,000 since demonetization. The ministry is also trying to streamline the law to ensure that only small firms are converted into LLPs, as was envisioned at the time of framing of the LLP Act. The fourth point, the change or the recent development relates to government on use of LLPs to weed out black money. Now there is a suspicion that inactive LLPs are being used for tax evasion and money laundering. After shell firms, the government is now concentrating on the growing number of limited liability partnerships and has started identifying and deregistering inactive LLPs which have no business, just registered for the sake of being registered as LLPs. The drive to deregister LLPs comes after a SEBI crackdown on 331 suspected listed shell companies. These steps are being taken to weed out the black money from the economy, and inactive LLPs can also be used for tax evasion and money laundering. New LLPs and companies converting to LLPs spiked after the Companies Act 2013 came into effect in April 2014. As on June 2017, over 6,000 companies converted themselves into LLPs. There were 94,304 active LLPs as of June 2017 according to MCA data report. Now, a plausible reason for the increase in LLPs could be that certain existing companies do not require any approval from the government to convert into an LLP. LLP also require minimum compliance and regulatory requirements. Like an LLP, as you know that LLP is required to file only an annual return and a statement of account and solvency, and the other filings are event based. For example, like if there is a change in the LLP agreement or if there is a change in the partners, etc. For the last 2 years, the government authorities have liberalized norms for FDI in LLPs, which allow them to appoint foreign partners and allow LLPs to avail external commercial borrowings. Just now I told you about such a change. Now, if there are no business activities in LLPs for 2 years or more, then as per the law, ROC can deregister such LLPs if it is not satisfied with the reason for the firm's inactive business trends. And the last issue is related to amendment which the government is proposing in section 67 of the LLP Act. Now under the amendment, the government can impose sections of Companies Act 2013 on LLPs in the public interest, like many provisions like capping the number of partners, authorizing registrar of companies for inspection, and implementation of accounting standards will be applied to LLPs also. So this is one of the biggest changes which is going to come soon. Currently ROCs have the power to inspect companies but not LLPs. So by increasing the rights of the ROCs, the government will be able to take action against the entities which are taking the shield of LLPs Act and hiding their business activities. Now we come to the end of this session. In the end, to summarize, I can put in brief, a very brief, that with LLP, professionals and entrepreneurs would be able to form a multidisciplinary partnerships. Flexibility of operations will be a key benefit, as board or general and extraordinary meetings and all these meetings are not going to be required to conduct the business of the LLP. Business can be expanded easily depending upon the increases in the area of operations. Then there will be limited procedural formalities which are going to be there. The liability of LLP is met out of the property of the LLP. The partner is not liable. A partner is not responsible for the wrongful acts of the other partners or omissions of the other partners. The Act provides minimal barriers to entry and exit for LLPs, and there are no restrictions on the scale of business. Separately and together, the provisions entail no collective responsibility for every action of the LLP. The LLP also does away with the limited notion of accountability to shareholders that joint stock companies with limited liability have to adhere to. In the WTO scenario, services are bound to play a vital role in development in developed and developing countries alike. LLPs rendering professional services may thus grow in size in the process of neoliberal globalization. Furthermore, as a foreign LLP may enter India and establish itself without any restriction and reciprocal arrangements, indigenous LLPs may slowly go out of the business. Any individual or body corporate will be able to form an LLP partnership, private limited companies and unlisted public companies may convert into LLPs according to the provisions of the legislation. Hence, the LLP provides flexibility of reorganizing the holding structures of business groups, ensuring the legitimacy and perpetuation of existing forms of holdings. Moreover, a minimum of 2 partners are necessary for the formation of an LLP, of which one must have been a resident in India for at least 6 months prior to formation of the LLP. Thus, there are no stringent citizenship requirements which facilitate easy incorporation of foreign ownership, not just into LLPs but also within a business group without violating any of the other citizenship and succession and requirements for other forms of holdings. In addition to this, it provides easy entry and exit benefits to both Indian and foreign capital with the broad eligibility criterion of partners and provision for selective application after suitable modifications on the question of mergers, acquisitions, amalgamations and dissolution without altering the existing legislation that facilitates both asset concentration and expansion of capital accumulation. So, it can be concluded that LLP structure is the most desired and appropriate business form in today's globalized world for those who wish to grow in businesses from small and medium to big. Thank you so much and have a nice day.